Very much, Vanessa, for acceding to our request to be on this stream.
Thank you very much. And time is not our friend. There's another session after mine, so I will go straight into it. I'd like to appreciate the NBA ICLE for putting together this series of programs. And I would also like to appreciate the organizers of the 2024 session for inviting me to be a facilitator in reminding all of us, the participants, and even those of us who are supposed to be renewing your knowledge of the basic principles of civil litigation. I'm going to talk to you today about examination of witnesses. And examination of witnesses is the center of your dispute. And why do I say this? Now, if you go to the next slide, please, Mabel, you will see the relationship between the case and the witnesses. At the very first session, when Mr. Oshobi SAN was introducing this program, speaking about civil litigation, he mentioned the fact that litigation is like building a house. You have to put different pieces together to have one complete whole, which, if you have put it together in the approved format, will shelter all the inhabitants and will be a long and enduring structure. So I'm going to continue with that analogy of saying that litigation is like building a house. And when you build a house, as we all aspire to do, your house consists of a foundation, pillars, and beams. And let us say that the facts of the dispute are the foundation for your house. That's the basis of your case, your claim, the dispute. Now, the pillars and the beams are your pleadings, because they are what holds the structure together for your case. Your foundation are the facts that have caused the dispute. When you put your pillars and your beams together as your pleadings, they have to be joined up. Otherwise, you don't have a house. You may have some sort of a structure, but definitely it is not a house that will cover you. If you're building a house, the pillars and the cement beams are joined together by cement blocks. Those blocks are your evidence. A case is won or lost based on the evidence that is presented. That evidence can be oral or documentary. Oral evidence is presented through witnesses, and they will tender documents which will be documentary evidence. So the relationship between the case and the witnesses is your evidence, and your evidence is going to be presented by those witnesses. If you do not have witnesses to support your case, then you do not have a structure. And I would like, at this point, to refer you to what I consider to be a major statement discussing the relationship between the case and the evidence that proves that case. Can we go to the next slide, please? And I'm going to give you a moment to all read the quotation or the citation of Kayode Esho, JSC, in the case of Ibrahim and Shagari, where, in my view, he clearly explained the relationship between your case and the evidence. He says a court of law can only decide issues on the evidence put before that court. The rules governing the procedure in the court are so elementary when it comes to presentation of evidence. Hence, the person who alleges presents his witnesses who give evidence in chief. That is as per the case he intends to put forward. The witnesses are cross-examined so as to put forward the case of the defendant across, and also to test whether or not the witnesses are witnesses of truth. Indeed, during cross-examination, the defendant is at liberty to put as many questions as are material to his case. He could even be cross with the witness in his examination, as the word cross-examination implies. There could thereafter be re-examination to put right any adverse points wrongly elicited during the cross-examination. My dear learned colleagues, this summarizes the relationship between the case and the evidence. And evidence is presented by witnesses who will give their evidence by way of examination in chief, who will then be cross-examined and re-examined. So first step, examination in chief. Next slide, please. Examination in chief is the evidence of your witnesses. You're putting your case across through them. And most courts have now moved from a system of oral evidence, except perhaps in the lower courts, but in most of the high courts, the evidence in chief is presented by way of a witness statement. And the purpose of the examination in chief is to put forward your evidence in support of your case. Now, if you go back to our analogy at the beginning of building a house, your evidence in chief is when you, as the builder, you start placing the evidence blocks between the columns, which are your pleadings, and you're fixing them together with the cement. Your case succeeds or fails based on the evidence you have presented to the court. Ibrahim and Shegari. So that's your evidence in chief, your own witnesses. Now we'll see on the next slide that examination in chief is limited. It's limited to introduction of the witness, confirmation, or if necessary, correction of his or her witness statement, the adoption of the witness statement, and the tendering of exhibits that have been referenced in the witness statement. And so going back to previous sessions that you have listened to, preparation is key. You fail to prepare, you prepare to fail. Your witness statements are your evidence in chief. They are vital to the case you are going to present. And in essence, your ability to win is based on your witnesses and how they stand up under cross-examination. So what's the purpose of cross-examination? The main purpose of cross-examination is to destroy the opponent's building. The claimant is trying to put a case forward and he's building it block by block, calling one witness after the other to support the pleadings he has given in court. Your job as defense counsel is to pull down that building, to destroy it. And how do you do this? You do it in three ways. You cast doubts upon the accuracy of evidence already given, either given by that witness or given by someone else. Put questions to the witness. Are you aware that Mr. So-and-so said so-and-so? And see how he's going to wriggle out of any inconsistencies. It's also an opportunity to elicit from the witness any evidence that is favorable to your case or to weaken the opponent's case. So he's given some evidence of what he saw. And you know that he wears glasses, but he didn't bring his glasses to court on the day. And so you now want to try and say you couldn't have seen what you saw, or say you saw, or you couldn't have seen it clearly because you weren't wearing your glasses. And so you start asking questions that the witness is wondering, why is he asking me whether or not I wear glasses every day? Because I'm not wearing them today. Do you need them to read? Do you need them to drive? Are you short-sighted or long-sighted? You are basically trying to destroy the evidence that witness has given under cross-examination. And it's also an ideal opportunity to advance your own client's case. You've heard judges talk about you must put your case to the witness. And so cross-examination is an ideal purpose, an ideal opportunity for you to ask the witness, you are aware, are you not, that this is what my client says. He's either aware or he's not. We'll come to the issue of questioning later. But the purpose of any cross-examination is to destroy the opponent's case. And how do you do this? There's something that's called the funnel technique. You have a whole lot of water. You want to put it into a container. So you take the funnel and you put it into the top of the container and you pour the water in. And the water drips down little by little, drop by drop, until it fills the container. So the funnel technique is called close-ended questions, used in an intentional sequence. And you're using it to establish a specific fact. So for instance, you want to discredit the opponent's version of a car accident that your client was involved in. You don't go straight to the end point, which is, I put it to you that your version of how this accident happened is incorrect, because he will just deny it. So you go step by step. Only you and your brother were in the car at the time of the accident. He says, yes. Who was driving? I was. You wear glasses? Yes. What time of day was it? It was night. It was about 9 o'clock. There were many cars on the road at the time. Yes, the road was busy. And you ask the questions in that format to extract from him the fact that it was night, you wear glasses, you didn't see as well as you could have seen because it was dark. There were many cars on the road. Those cars also had their headlamps on. Their headlamps could have distracted or would have distracted your vision. And therefore, what you thought you saw is not what you saw. And that's called the funnel technique. You go step by step, building your case using something called close-ended questions. And now we'll talk about the type of questioning you use when you're examining witnesses. Questions are guaranteed in life, but answers are not. So the first thing you need to understand is avoid asking open questions. Questions where you don't know the answer. It is not in court you want to find out that answer, because that answer may be something that does not help your witness. Open questions are inquiries. In an open question, the witness talks more than the lawyer. You want a witness to answer your questions, yes, no, or in a specific fashion. If you ask open questions, they give control to the witness. Tell the learned trial judge why you say my client was the one who hit your car. He's going to go on a story. He is going to go on a story. A close-ended question is one that restricts the type of answers that the witness can give to either yes, no, or an explanation. And sometimes it is when you hear a close-ended question that the witness says that, yes, but. And then you say, no, I'm satisfied with the answer. Sometimes the judge says, okay, let him say what the but is. And that then gives him an opportunity to explain. But a good, tight, close-ended question goes straight to the point that you have made. Vital under cross-examination, never ask a question unless you know the answer. It is not in court that you want to discover an aspect of your case or an aspect of the facts in dispute that you are not aware of before. And that takes us to yesterday's lecture, preparation. Preparation is key. You must know your case from beginning to end, and you must know your opponent's case from beginning to end. So let us look at some open questions which give control to the witness, the type of things you shouldn't be asking under cross-examination. So when you ask a question, what did you expect? You're asking the witness to say anything. How was this different from what you expected? You're still asking him to say anything. You have no idea what it is he's going to say. You're actually searching for information. Cross-examination is not the point where you search for information. You search for information when you are preparing for trial, when you are drafting your witness statement, when you are collecting the evidence you're trying to put forward. What do you think about this? Apart from the fact that you're asking the witness for his opinion, which an astute lawyer will quickly jump up and say, my lord, I object, that question is not relevant. The witness is not an expert. His opinion is of no use. And perhaps you'll be lucky and the judge will agree with you. So what he thinks is not relevant. How did you feel about this? Also, I was very upset when I heard or when I read the letter. It's a defamation case. And you're asking him, how did you feel about this? You're giving him every opportunity to tell you how defamatory that letter that you are trying to defend was. How do you know? Unless you know how he knew. And you're going to be prepared to cross-examine him if he tells a lie. Don't ask, how did you know? Because a very open-ended question. Other than he says, oh, somebody told me, and you can then object and say that's hearsay, it's not admissible. But if he says, oh, I read it, oh, I was given a document. So open-ended questions give control to the witness. Let's go to the next slide and look at the correct technique for cross-examination. Cross-examination questions should be closed questions. They're statements, they're not inquiries. You're telling the witness, you're not asking the witness. So you say something like, you saw the claimant when he signed Exhibit A. His answer is, yes, I did, or no, I didn't. He doesn't have much room to maneuver. So closed-ended questions are questions that can only be answered by selecting from a limited number of options. They keep the witness under your control. And because the witness is under your control, you know the type of information that you want to extract from that witness. So closed questions control the witness. Can we go to the next slide? And then we'll look at some examples of closed questions. Was it what you expected? Yes, it was. No, it wasn't. I was quite surprised. It limits the answers. Did you expect that to happen? Yes, it did. Yes, I did. No, I didn't. I was surprised. Does this make sense to you? Either it makes sense or it doesn't make sense. Was it stressful? Yes, it was. I was very uncomfortable. No, it wasn't. I don't feel anything at all. You have limited options. Did you know what happened at the scene of the accident? Did you know that the police were called when the accident happened? Yes, I did. No, I didn't. I only saw the police there later. So closed questions control the witness. Now let's look at a comparison of the two types of questions. A closed question, was it what you expected? Did you expect that? You've limited the answers that the witness can give. An open question, what did you expect? He has a range of answers. Was this different from what you expected? He also has a range of answers. Does this make sense to you? Yes, it does. No, it doesn't. What do you think about that? He'll tell you all sorts of things. So you've given him the opportunity. Was it stressful? That's a closed question. It was extremely stressful. I was very upset. How did you feel about this? Oh, he's going to tell you his emotional damage, how upset he was when his sister and his brother called him and told him what had happened, and he was so upset. Did you know? Is a closed question. How did you know? Is an open question. Because you're giving the opportunity to tell you a story, and that is not what you want. So we look at the 10 commandments of cross-examination. And if you take these 10 commandments to heart, whatever type of case, be it a criminal matter, be it a civil matter, you will surely be able to extract the information that you require from the witness, redo any damage that any previous witness has done to your case, possibly show up that the witness is not a witness of truth, but definitely you will maintain control of your case. So the 10 commandments, be brief when asking questions. You have closing address, closing argument, written closing submissions. Keep your story for them. Asking questions, stay in charge by short questions. Be brief. A long question can actually end up confusing the witness. He's trying to answer you. He says what you don't want him to say. So that's the second commandment. Be brief. Secondly, ask questions that use plain words so the witness is not confused. So he has no option than to answer the question you have put to him. Cross-examination, ask only leading questions, questions that take you to the answer that you want. It is permitted under cross-examination. It is not permitted under examination in chief. For cross-examination, you are at leeway. However, do not ask a question if you do not know the answer. Because when that shot comes at you, you'll be scrambling as to how you are going to answer it or redeem the damage. And if the judge sees that, oh, you're suddenly not sure of your case, even if the judge doesn't say anything or the magistrate doesn't say anything, you can be sure that that point has been noted, that the witness destabilized the counsel. So don't ask a question if you don't know the answer. Then when you've heard the answer, follow up only if it is necessary. Sometimes the witness presents you with that pearl from the oyster that you've been looking for. And if he opens up and presents you with that, of course, grab it by asking the necessary follow-up question, but only if it is necessary. Do not quarrel with the witness. We've all heard the story of a man fighting with a pig. They are both rolling on the ground and getting dirty. And at a point, people will not be able to differentiate between the man and the pig. You are not the witness. So you have to maintain your composure and don't allow the witness to rile you or upset you with the manner in which he's presenting his evidence. You have to stand above the fray. Do not allow the witness to repeat his or her direct testimony. If you've asked the witness something in cross-examination and he's trying to cut him off. Thank you. You've already given that evidence in your evidence in chief. That's not what I'm asking. This is what I'm asking. Number 8, do not permit the witness to explain. You can be polite about it. Oh, I'm sorry, I don't need that explanation. I'm definitely not confused. I understand what you said perfectly. Let me explain. No, thank you. I don't need an explanation. I'm satisfied with your answer. Unless the judge decides, no, let him explain. Maybe because the judge hasn't then understood either your case or what the witness has said. 9, don't be greedy. Don't ask too many questions. Don't cross-examine for the sake of cross-examination. There must be a purpose. If the evidence of the witness is useless to your case, I have no cross-examination, my lord. That's it. At the same time, if you have cross-examination, go after the cross-examination, but not endlessly. Not to the point where the judge says, learned counsel, how much longer? You've lost the judge. But the judge says, learned counsel, is there more? Maybe we should take another date. It means your cross-examination is going on for too long, and you've perhaps lost the judge on your side. And finally, know the facts you want to elicit from the witness, which takes us back to yesterday, preparation. You must know your case inside and out. You must know your facts inside and out. You must know the facts that you can get from that particular witness. So now let's look at pitfalls. This is when cross-examination goes wrong. And these are the things that you need to avoid. You're not prepared, which means you haven't read your case inside out. You haven't read all the witness statements. You haven't understood the legal issues that you are putting forward or the legal issues that the opponent is putting forward. So you're not prepared. Witness says something and you're thrown. And you start shuffling papers here and there. I'm sorry, my lord. My lord, if you just give me a moment, and then you are opening another file. I'm sorry, my lord, I'm just looking for an exhibit. You're not prepared. Avoid. You harass the witness. Don't harass the witness. It's called bullying. It never works out well because you may end up with a judge who may take the view that you don't have a strong case. And so you're trying to harass the witness into agreeing with you. You need to be polite to the witness at all times, not abusive. Even if the witness says something that hurts your case, you don't harass him. And another pitfall is when the witness has said something that hurts your case and you don't camouflage it. You make it worse. So sometimes you've asked a question to which you didn't know the answer. And that witness has now given you an answer under cross-examination that supports his own defense or his own case and hurts yours. And instead of your camouflaging it, perhaps by saying, I take it that this is the defense that you are relying upon, end of story. To which you say, yes, end of story. You make it worse by trying to now dig into what he has said and opening up the wound for him to be puncturing more and more. And if a witness feels that he has the better of his lawyer, you can be sure that that witness is going to try his worst to damage your own client's case. Another pitfall, do not allow the witness to show off their expertise. Sometimes you have witnesses who are experts. So it's a medical negligence case and you're cross-examining a doctor. Apart from the fact that you need to yourself have read up on various medical techniques that are relevant to your case so that you can show the witness that you know as much about that aspect of your case as he does. Otherwise, The witness will show off his medical expertise, give the judge the impression of, my lord, this lawyer doesn't know what he's talking about. And then the judge starts to feel, oh, maybe you don't know your case. So never allow the witness to show off their expertise. You need to do your research, do your homework, and ensure that you are up to speed in the issues that underline the dispute. And finally, avoid asking long, complicated questions. Because by the time the witness says, please come again, I didn't understand. Please come again, I didn't understand. The judge is going to start wondering whether he himself understands. And by the time the judge starts saying, are you asking, why don't you put that question again? The judge starts to feel sympathy for the witness. The last thing you want is for the judge to be sympathetic to a witness that you are cross-examining. So you've concluded your cross-examination, you then go to your re-examination. And re-examination is very limited. It is not an opportunity to put your case to your witness again. It must be restricted to matters raised during cross-examination. And it is basically to allow the witness to explain any inconsistent answers. In your evidence in chief, you said you were at the scene of the accident at 7:40. Under cross-examination, you told the witness you were there at 6 o'clock. Could you explain this inconsistency? And then you'll allow the witness to say, actually, I got there at 6 o'clock. I was there up till 7:40. So that's how you use your cross-examination. It is not for putting a new case. As you can see from the current slide, the purpose of the examination has been clearly stated. It is the opportunity of explaining any seeming inconsistencies in his answers and giving him the opportunity to clear any doubts in his testimony. And it is not an opportunity to raise new matters without the leave of the court. So if a new matter has come up under cross-examination that was either not pleaded or not referred to, then you need to ask the learned trial judge for permission to re-examine him with respect to this matter, which did not arise in his examination in chief. Next slide. In Mohammed and Bubu, note that it is also an opportunity to restore credibility to his testimony, not by going over his examination in chief again, but by ensuring consistency in his statements, by matching his cross-examination with his examination in chief. Can we go to the next slide again? So your re-examination, I would refer you to the statement of Onogen, JCA as he then was, before he became our CJN. He says, re-examination is in order to explain, if possible, the contradictions between the appellant evidence in chief and the evidence elicited from them on the issues under cross-examination. So re-examination is extremely, extremely limited. And that's why you have a lot of objections during cross-examination. My lord, there's no inconsistency. My lord, there's no contradiction. My lord, I object. This question does not arise for re-examination. I would like to conclude by saying that you need to be very, very aware of your Evidence Act, because the purpose of examination of witnesses, sorry, is to extract your evidence from your evidence in chief, which is written, and your exhibits, and to extract or elicit supporting evidence if possible, or destroying evidence under cross-examination. And that basically is governed by your Evidence Act. You cannot be a good civil litigator if you are not totally at home with the rules of evidence in the Evidence Act. Thank you very much. And I think we have 20 minutes for questions.
Thank you very much, Leonard Silk. We do appreciate your excellent presentation. It's as expected. It's very clear, concise, succinct, and it addresses all the issues. And it's very accessible and very easy to follow and understand. We truly appreciate it. I hand over to Mrs. Mabel Okirike to conduct the question and answer session. Thank you very much again.
Thank you to you. Thank you, Leonard Silk. I'll just very quickly, because we have lots of questions here. Good afternoon, Leonard Silk. I would like to know if a deceased respondent in a fundamental rights enforcement matter can be substituted. This is outside
this is outside the scope of this speech.
Yes. Disu Olowo Yefekun says, if a land grabber unlawfully sells another's land and the original owner wins the case in court and is declared the owner by the judgment, but the buyer, who was an innocent purchaser for value without legal notice built on it, will the original owner be able to recover the land? I heard the landowner is usually just given a cash settlement, but usually gets his land back. Thank you. This is also out of, but we don't know if the Leonard would like to oblige them.
What I would say to the first question, which is outside the scope of my paper, is that I would be surprised if a deceased respondent to a fundamental rights enforcement action can be substituted, because it's a personal action. However, that's as far as I would go on that one. For Mr. Olowo Foyeku's question, purchasers for value without notice will probably be able to raise that defense such that the original owner may not be able to get his land back. So if there have been supervening third-party rights and have been established to the satisfaction of the court, then you may have to just have some sort of a settlement.
Uchenna Ogamba, good afternoon, Leonard. So thank you very much for this well-covered lecture on examination in chief. Please, my question is, what is the effect of asking repeated questions to a witness during cross-examination, especially to provoke the witness?
I would definitely advise against that. Why do you want to provoke the witness? You need to ensure that the witness is constantly under your control. And therefore, if you've asked the question and the witness has not answered it or has not answered it to your satisfaction, then you ask him the same question in a closed form. I put it to you that, whatever it is, and he says yes or says no. But if you provoke the witness, you may end up in a situation where it seems as if the witness has taken control of the case. And instead of the judge thinking that the witness is a witness of truth, the judge is just going to feel sorry for you, the lawyer. You see how the witness is treating you.
Thank you. Karen Chuku says, how does a witness speak to a document to avoid dumping during examination in chief?
Dumping of documents is something that actually has come up as a result of election petitions. But what the counsel should do is to lead the witness. In fact, at the case management stage, parties should actually have agreed on the documents that can go in by consent and the ones that they wish to object to. But in essence, to avoid dump, you lay the foundation and you reference the exhibit and you put it in, and that's it.
Thank you, Leonard Silk. Uchenna Ogamba, is it necessary to ask so long questions to a witness? Please, what is the effect?
You may lose the trend of your own thoughts and you confuse the witness. And if your questions are so long and the witness then gives you an answer you don't want, you've lost control of your case. So you ask a short, closed question, a series of short, closed questions that will take you to the answer that you are looking for.
This is from an anonymous attendee. Let's look. I don't know if you want to answer this. There is a judge in the FCT High Court who will always allow a witness to say whatever he or she wants under cross-examination. When you try to stop the witness, the judge will tell you to allow the witness, that the witness is entitled to give evidence. What do you do in that situation?
It sounds to me that that might be a situation where you have asked open-ended questions and the witness is then answering openly and you're now trying to shut him down. But if you ask a close-ended question, it becomes very difficult for the witness to go on a rampage of his own. But if he does, really, there's nothing much you can do about it. If the judge says, no, allow him, other than to smile and say, thank you very much, my lord. And maybe when the witness finishes to say, do you have anything else that you would want to let us know?
Thank you. Yusuf Ali Bulama, what are examples of leading questions?
Leading questions. A leading question is a question that invites its own answer. So a leading question is, you were there on the night of the incident. Yes, I was. That's a leading question. A leading question is, you are the one who sent your brother to school. Were you not? That's a leading question. Leading question invites its own answer.
Doko Opanachi says, thank you, Leonard Silk. Says you made my something. Anonymous attendee, in cross-examination, what are the pitfalls to avoid? I was late, network issues.
Okay, because we have someone else coming on at 4 o'clock, I would say that you would receive the list of the pitfalls to avoid. They're part of the presentation.
We will circulate the slides.
Ike Wandu says, thank you very much, Leonard. What is the effect of witness statement on oath not signed before the commissioner for oath, but the commissioner saw and knew the deponent?
A witness statement that was not signed before the commissioner of oath is not a witness statement. It's as simple as, because a witness statement must be signed and on oath.
Abiodun Jomo says, where a witness statement on oath is inadmissible because it's not sworn before a commissioner for oath, what becomes of the cross-examination?
There would be no cross-examination. I'm sorry, I'm not sure that I understand that question. If the witness statement is not allowed because it was objected to on the grounds that it was not sworn to, then there's no examination in chief. And therefore, there's really nothing to cross-examine the witness on.
Thank you. Shikarodu Umahi says, good afternoon, Leonard. Is it injurious to the case where a witness says under cross-examination that he signed his witness statement on oath in his lawyer's chambers?
It depends on the circumstances of the case. If the witness statement states that it was deposed to before a commissioner of oaths in the High Court, and under cross-examination, he then says, I signed it in my lawyer's chambers. It was then taken to court and stamped. Then it goes as to the weight that will be given to the evidence of that witness at all. It's still a sworn witness statement. It's just that it was not sworn to in the place where the witness says it was sworn to, not in the High Court, but before the notary public.
Thank you very much, Leonard. So this is from an anonymous attendee. Thank you very much for excellent presentation. What is the probative value that will be attached to the evidence elicited from a witness during cross-examination but was not pleaded?
The judge is entitled to take into consideration all evidence that is presented before him. And so this goes to the separation of facts as opposed to evidence. And I think we are clear that you must plead facts upon which your case relies, but not evidence. So as long as what has been elicited is evidence, and it is evidence in support of facts that are pleaded, there's nothing injurious about it. Should be admitted. There should be no problem.
Thank you, Leonard. So Patrick Eagle says, what is the propriety of a court giving a counsel 15 minutes for cross-examination of a witness?
I would suggest, I would find it hard to believe that a court would do so, because it would mean that a counsel is not being given an ample opportunity to present his case. And presenting his case is both by way of evidence in chief and cross-examination.
Thank you. Ifeyua says, is there any scenario where riling or deliberately upsetting a witness via innocuous, in quotes, questions might be favorable to cross-examining for the counsel?
It could depend on what you must have a reason for deliberately riling a witness. You must want to show something, either that the witness has a hot temper, if the hot temper is a fact in issue, or some other fact that you want to establish. But to rile or upset a witness just for the purposes of upsetting the witness, I would not advocate it.
A. Kere Kubana says, please, does the mere fact that a witness contradicts himself under cross-examination automatically give rise to a re-examination? If yes, isn't that prejudicial to the other party whose aim is to create doubts, including self-contradictions?
Contradictions during cross-examination do not automatically give rise to the ability to re-examine. It is where that re-examination is to remove an inconsistency. That is when the judge would allow it. So if you have cross-examined and you have come out with inconsistent statements that merely show that the witness is not a witness of truth, then I would advise that the counsel that presented that witness not re-examine, just walk away and hope that it has not been taken note of. Because otherwise, the other side will immediately stand up and say, my Lord, there's no inconsistency, there's no contradiction. He said this, and he said that. That's it.
Very well, thank you. Collins Ugochukwu says, thank you, Leonard Silk. When will you say is the most appropriate place to stop cross-examination, as many lawyers keep going on and on until their time runs out?
Simple. It goes back to what we have said in the previous lectures. Preparation is key. You can't cross-examine unless you have a plan. So you must know your case. You must know what you want to extract from that cross-examination. And once you have extracted the information you want from that cross-examination, you stop.
Thank you, Leonard. So this is from WB. What happens to a document that was not referred to in a witness statement and oath? Can it be tendered in evidence?
Yes, it can. Look at your Evidence Act. And that's why I say it's important that any litigator must be very much at home with his Evidence Act. You can tender a statement that was not part of a witness statement of oath, was not on your list of exhibits, if you want to show a particular purpose. And the Evidence Act specifically refers to those circumstances where you want to prove that the witness has given a previous inconsistent statement in writing. So he says something under cross-examination, or he says something in his evidence in chief, and you now want to challenge him by showing him a statement that he has made in writing that is inconsistent with what he has said, but you must lay the proper foundation.
Thank you, Leonard. So this is from an anonymous attendee. Thank you so much, Leonard Silk, for the eloquence. In a criminal case, where the IPO claims to have visited the crime venue, when in fact he did not, would it be right to ask him to describe the crime venue during cross-examination?
Yes, it would, but you need to be sure that he did not visit the crime venue, that you have visited the crime venue. And so you're able to actually cross-examine him on any evidence that he gives. So you need to be absolutely certain that he did not visit the crime venue. He may have been, but not at the time you all agreed he should go.
Thank you. What is the effect of documents referred or pleaded in witness statements on oath, but at the end of the day, the witness couldn't highlight the document while under cross-examination due to the bulkiness of the document?
I'm sorry, could you repeat the question?
What is the effect of documents referred to or pleaded in a witness statement on oath, but at the end of the day, the witness couldn't highlight the document while under cross-examination due to the bulkiness of the documents?
I'm not sure that I understand the question. If the witness is going to the issue of what is the status of exhibits that have been attached to witness statements but are not specifically referred to, they still form part of the case file. Whether the judge gives any attention to it or not is a matter for address by either parties. If the witness is not cross-examined on the basis of documents that he has referred to in his witness statement, and those exhibits have been taken into evidence, they are uncontradicted.
Very well, thank you. What is the faith of witness statement not deposed to before commissioner, but adopted after oath, administered in open court?
There does seem to be case law on that, but I cannot immediately remember it. I believe that there is case law. I don't want to commit myself. I think the case law actually says that it is a valid witness statement if it has been adopted under oath in court. But I can't be 100% certain.
In the era of e-filing, is it necessary that a witness is taken before a commissioner of oath?
I'm yet to see how that e-filing thing is going to work. Rarely you need to go before a commissioner of oaths. That's what our oaths law or oaths act says. So you probably have to go to have your document sworn to and then upload it. That is e-filing.
There's a question here from Oluwapelumi. Says, what is the difference between facts and evidence? In my opinion, evidence is a series of facts.
It is a thin line. Evidence is the material. That's the way I would put it. Evidence is the material which is used to prove the facts that are in contention. So to the extent that a fact is a document, yes.
Thank
but
you.
to the extent, no, I haven't quite finished because
Right.
there's a point that I'm going to. But to the extent that a fact in issue is a scenario, you plead facts in issue. And the point that I'm trying to make is that one of the things that we should never do as litigators is to take your statement of claim and put I deposed to, I swear on oath, and then you dump your statement of claim as your witness statement. That's not how you draft a witness statement. A witness statement should contain the facts in dispute, but also the evidence that is going to support those facts. But I've seen so many instances where people just take the statement of claim and then they put, I am the claimant, like this, and they just take the whole thing again, and that's their witness statement.
Thank you, ma'am. Abiodun Ojomu says, where all the witnesses are discredited on the basis of their statement and oath during cross-examination, what becomes of that party's case? Can it rest only on pleadings?
Obviously not. I'm sure Mr. Ojomu knows that himself.
Good day, Leonard Silk. What becomes of a document front-loaded but not formally tendered in evidence?
If it's not formally tendered, it may be part of the record in case you want to go on appeal, but it's not an exhibit. Because once it's tendered, it will be given in an exhibit number. And I am aware that we're heading up for 4 o'clock. It is about time for the next.
Yes. I think this is just 1 minute remaining. I possibly can exhaust the remaining questions that I have here, but I must join the participants. We have loads of comments, hundreds plus. So thank you, Leonard Silk, for such a very practical, interesting, insightful session with you. Thank you very much.
Thank you.
It's my
pleasure.
Thank you very much, Leonard Silk. Your presentation was very much appreciated. And questions, answer session, and even more so in giving clarification to all the issues. We thank you so much. These are you are highly appreciated. For our colleagues, a number of them were asking, but particularly those who joined late, the slides will be shared to everyone. We have the Leonard Silk slides that we will share with everyone in due course. Thank you very much. So we're going over to the next session. Our speaker is on standby. The next session deals with, well, basically it's dealing with final addresses. After you've elicited your evidence, whether by cross-examination, re-examination, examination in chief. At the close of your case, you have to critically appraise and analyze your evidence, and the evidence, all the evidence on record, in fact, not just your evidence, but the evidence of your opposing counsel. And of course, you appraise the evidence, you evaluate value, and you try and persuade put them on the imaginary scale and try and persuade the court based on, of course, on analysis of the evidence and the law that the case should be resolved in your favor. And that's what you do with your written address. To deal with this issue, we have a very, very, very eminent colleague of ours, Mr. Ogokwabi, to speak to this. He's dialing in all the way from Canada. He's qualified to practice in Nigeria. He's gone to Canada, he's excelled, and he's a King's Counsel. He's a silk in Canada. I would we thank him for joining us. I would hand over to my colleague, Mrs. Okereke, to read out the short bio of Mr. Ogokwabi.
Thank you very much, Leonard Silk. Without much ado, Dr. Okwabi is founder and principal at the Republic Law, a corporate commercial business law and civil litigation law firm in Calgary, Alberta, Canada. Dr. Okwabi completed his doctorate in law at the Osgood Halls Law School, York University, Toronto, Canada. As well, he was a Virtues Fellow at the university at the Michigan Law School, Ann Arbor in USA. Before establishing the Republic Law, Dr. Okwabi worked for years at one of Canada's largest national law firms. Dr. Okwabi possesses a wealth of experience as a highly respected litigator, specializing in corporate commercial transaction and civil business litigation. With over 2 decades of expertise and a comprehensive understanding of different legal markets, Dr. Okwabi has exposure to legal regimes in Nigeria, Switzerland, USA, and Canada. He's a certified doctor, completed as well a John Ware Fellow at the D. Good School of Business in McMaster University, Ontario, Canada. Dr. Kwabi recently completed a 3-year tenure as a member of the highly sensitive Provincial Contemplating Committee, a provincial body responsible for interviewing prospective judges at the Alberta Court of Justice. In 2022, Dr. Kwabi was one of the few select lawyers appointed the rare honor and designation of King's Counsel. He is also an adjunct and a sessional professor of law at the University of Calgary Law School. He volunteers extensively and is currently co-chair of the Calgary Association of Nigerian Lawyers, as well as a trustee of the Nigerian Canadian Association of Calgary. Without much ado, you're welcome, Mr. Kwabi. Thank you much for acceding to our request and being on this training.
Hello, everybody, and thank you for that generous. Can everybody hear me?
We can hear you very clearly, loud and clear.
Thank you.
And we can see you too.
Thank you for that very generous introduction, Mabel. And thank you, my learned silk, Tola. Tola and I were in law school together many years ago. And I also want to thank the the Nigerian Bar Association. I think this is a very important project with respect to sort of continuing legal education. Continuing legal education here in Canada is extremely important. Should you have any challenges with respect to the Law Society here, they're going to look at your continuing legal education credits to see whether you're working in the area or you've sort of had extensive exposure in the area where you're practicing. And that might be taken into consideration in deciding how they sort of rule on an issue that comes before them. So this is very important. And that's why when Tola mentioned this opportunity, I decided to see how much I can help. Now, I left Nigeria 20 or so years ago. I haven't, been in Nigeria for a while, but I mean, I keep an eye on what goes on there. And so one of the things I propose to do in the context of this, and let me just share my slide here.
Abby, I think you need to release the yeah.
Can you see my screen? I don't think this is.
Yes, we can. We can see your screen.
You can see my screen?
Yes, we can.
Wow, I'm not seeing my my presentation. I'm wondering whether this has to do with Mabel, but anyways, if you can see, that's fine. And so one of the things I hope to sort of do here will be to sort of deal with issues that are sort of transcendental and not necessarily sort of limited to any particular jurisdiction. Now, the title is not mine. This is a title that was given to me. It's a bit of a mouthful, but it is what I have to work with. Like I said, I want to share some reflections concerning the relationship between evidence, and this evidence would have a double meaning. Evidence could mean sort of the inference that can be drawn with respect to an existing order of things, and also the law applicable to such inferences. And so in some sense, I will be using evidence in a double meaning, having a double meaning. And looking at it in the context of trials here. Crazily, trials, as I know also in Nigeria, are very expensive, and we settle more, or we go to alternative dispute resolutions rather than go on trial here. Because, if you think trials in Nigeria are expensive, they are incredibly expensive here. And so increasingly parties have, tried to figure out ways to sort of channel things in a different direction than going the sort of the ultimate pathway of trials. Now, like I said, I appreciate the systems are different, but again, the systems are very similar. In fact, when students are transitioning from Nigeria to here, I actually have 2 Nigerian students right now with me who are doing sort of a process of articles. The process of articles sort of looks like what you do in law office attachments and what you do in court attachments. So it's a period of practical training that you have to go through after you write the challenge exams. Now, it's very different in a sense, but also very similar because, of course, we both owe our traditions to the English common law. And in fact, in most instances, when I stand up to speak in court, it just seems to me that I'm speaking to a Nigerian court. The issues of evidence, the issues of sort of stare decisis, the issues of precedents are still the same. They just really don't differ. The intellectual heft we bring to the issues concerning particular cases, distinguishing particular cases, are the same. They really don't change. Of course, the statutes are different. Of course, we don't go to the white book like Nigerians do. We have enough jurisprudence within within the province here or within the country to settle any issue. And so we don't necessarily go beyond Canada to start looking at cases. In some instances we do, but they are really persuasive and not necessarily determinative of the issue before the judge. Now, looking at the topic, I assume that, the overall teleological purpose of our conversation today was to reflect on how we might mainstream evidence to the issues arising in the context of a trial. Stated differently, the question is posed, how do we effectively marshal evidence grounding the issues in a trial? How does that happen? Because if the questions, the issues in a trial are unfeatured, in other words, if there's a misalignment between the issues in the trial and the evidence, then the issues are doomed to fail. There's just no way that the issue that you're advancing before a court, especially in a trial, can survive if you haven't sort of thought carefully about the applicable evidence that you need in order to sort of succeed on the various issues that are arising before the court. So, like I said, in sum, the evidence and the issues would have to align completely for you to stand any chance of success before a trial judge. Now, I'll give you some examples of what we do here when we are preparing for, what we call trial prep, when we're preparing for trial. One of the things we do is to workshop the material. If you think the documentation in Nigeria are sort of labyrinthine and sort of very extensive, over here we're talking about documents that are in electronic format. We're talking about documents that are in 40 bank boxes. We have over 2,000 documents that we have to sift through. So, the material alone can be daunting, can be, very, very, you look at it and you'll be like, how are you going to start? Where are you going to start? And, and for us in litigation, you just have to have the bench strength. I know that in Nigeria, based on resources, you can be limited to what, you can be limited in terms of what you can do, but you can really sort of approach a court here without having bench strength. And bench strength, I mean, you have the people, whether it's students or whether it's sort of associates or whether it's sort of assistants, looking at this document and trying to sort of unpack it and unpieces it and sort of trying to recreate it, just like a Lego block. And so when we say workshop, that means, for example, people taking different aspects of it, small bites of it, and trying to break it down and trying to bring it all together. That's what I mean. And so that just begins to give you a sense, as you dig deeper, a sense of what really are the issues, what really are the sort of the evidential borders that you're going to contend with as you prepare to get into trial. And as you're doing that, you're preparing a roadmap. You're preparing a roadmap, how are you proceeding? And I'll develop on that a little later in my talk. Developing a roadmap has to be flexible because as any litigator will tell you, things can take a different turn in actual trial. I've heard people talk about the theory of a case. You develop a theory of a case, but for me, that sort of spend time in graduate school, that really doesn't mean much to me. For me, a theory of a case must be sort of founded on data, and data is evidence. Data is the analytical heft that you bring to the evidence or to the fact. That's what is crucial. So the theory that just exists in the air without sort of a linkage to the facts, it just doesn't, it's not compelling for me. For me, the theory has to be driven by data. You just cannot survive without having the evidence, without having the data that sort of will ground any issues that you seek to sort of ventilate in a court. And so sort of to sum up here, you have to organize, you have to workshop the material, you have to pieces the material, you have to have a lot of people working with you. And of course, the unified purpose is to how to be organized, how to present data in a compelling manner, and ultimately how to bring the energy. This is the energy society. Nobody has time for people who don't have energy here. You have to bring the energy to the files that that you're bringing before the judge. And this judge's hell. I don't know the level of resources that you have in Nigeria with respect to the judges, but our judges are well resourced. They have lawyers that work for them. They have research assistants that work for them. Before you're citing cases to them, they know the cases. They've discussed it in conference amongst themselves. So you've got to bring the energy completely. If you ever find yourself standing before a judge concerning a trial. How do we sort of analyze the evidence? This is something actually preparing for a trial myself now. I have a trial coming up in October. And so sort of going through this process was a sort of a process of reminding myself of some of the things I need to do sort of in preparation for trial. How do we analyze the evidence? What is evidence? I suspect that Leonard Silk or Funke would have sort of talked a little more about what evidence is. We have a working hypothesis here that evidence refers to that which is adduced by a party at the trial as a means of establishing factual claims. Now, I wouldn't dwell on that because, I mean, we're lawyers, we have a sense of what is evidence. And even the Evidence Act talks about other things and not necessarily what is evidence. The Evidence Act of Nigeria. So background, types of evidence. Now, I mentioned the types of evidence here only because the way we typologize the evidence would invariably have implications of how they are analyzed and ultimately how they are presented in court. The nature of a particular piece of evidence, for example, bleeds into questions concerning the survivability of an issue raised at trial, how strong is the evidence advanced in support of a particular issue or trial, and therefore the relationship I would submit is direct. The better the evidence, the better the prospects of an issue raised the trial. Furthermore, the law applicable to the evidence would differ depending on its nature. In particular, whereas documentary evidence will contend primarily with issues of admissibility, oral evidence on its part will deal with matters related to hearsay rule and credibility. In sum, one should be mindful of the distinct legal issues raised depending on the nature of the evidence sought to be advanced in support of an issue. And so the way we categorize the evidence, the way we typologize the evidence will bring certain approaches in terms of how we deal with that. And it will flag different issues in terms of what we need to contend a trial. And that's probably what I'm trying to suggest here. And I go forward to further describe that in documentary evidence. These are the issues that we typically would see: admissibility, tendering judicial notice, relevance, materiality. And with respect to oral evidence, the kind of things that we'll see will be hearsay evidence, credibility, weight, and probative value, for example. And again, these things are not exhaustive. And thirdly, third-party evidence experts. There's almost no trial that we run here that does not bring in an expert. Some of the issues that arise with respect to third-party experts or third-party evidence will be sufficiency, weight, probative value, etc. These are the kinds of things that would arise in the context of the evidence trial. And of course, your approaches will differ depending on what the issue is or what the legal issues arise in connection to the type of evidence you are seeking to bring forward in court. Now here I call this the sort of the hub of the analysis: evidence and their phantoms. Disassembling evidence approaches to consider. These are the things that we have to deal with. I'm going to the trenches. I'm going to the sort of the nitty-gritty of how do we sort of pick apart these pieces of evidence, and how do we make it sort of digestible for the court in a trial. The first thing I suggest is what I call the bramble bush problem. Under here, the question I pose is, have we succeeded in segregating relevant facts from its inextricable existence with irrelevant facts? Relevant facts do not typically live in clinical isolation from its irrelevant cousin. As an initial proposition, I would suggest relevant facts must be decoupled from irrelevant facts. This is the typical problem we have right out of first year of law school. How do we, disassemble sort of a mash of data, from what is relevant and what is not? And, I sit as a sessional here. I lecture part-time at the university, the law school here. And our questions are fact pattern. We present a fact pattern from you. We call it issue identification. Are you able, sort of in that mess, figure out what is the issue? What is the relevant issue? So it sits sort of, it lives with a mass of things or a mass of data or mass of facts that are irrelevant, but only so much is relevant. And are you able to spot those issues and to sort of bring the law to apply to those issues? That's what we're talking about with respect to, have you figured out the bramble bush issue? Have you figured out what is relevant and sort of decoupling it or segregating it from that which is irrelevant? How do we do that? Well, the basic things that we learn in law school, and this is even in Nigeria, is that, the pleadings are appearing, they are a marker. They give us a sense of what are the zones of controversy. They delimit the zones of controversy. And the pleadings will give us a sense of what is relevant and what is not relevant. Now, this is a starting proposition. I am not suggesting that this ultimately, or it's completely determinative, but at least at a foundational level, it is the pleadings that give us a sense of what is material, or in other words, what is relevant and what is not. And if it is not evidence to what is not relevant, go to no issue. You're just wasting the court's time and everybody's time. What you need to focus on is what is relevant. Another way another thing that we look at is what we call a chronological order. A chronology of events, depending on the nature of the trial, might illuminate the issues arising therein, and as such, the evidential hurdles that need to be addressed. Hence, a chronology might illuminate as well as expose gaps in the evidence and the applicable law. And of course, there might be need to address them early, because if that uncertainty arises with respect to that amongst your team, chances are that 100% that uncertainty will arise with respect to the judge. The judge is also going to wonder. So it's better that you resolve that, perhaps organizing the events by way of a chronology. What happened at what stage, and you'll see that in a chart I have prepared, and perhaps that will give you some kind of order, because you have a mess of facts, relevant and irrelevant. How do you put structure? How do you structurize it so that it becomes intelligible, it becomes meaningful for your purpose and for the addressee, the third party, the judge, who is going to be listening to you at some point in time. I use this quite often, and I find it sort of works for me, but it may not work depending on what your subject area is. There's also what we call the outline. Now, this outline approach sort of presupposes that you've done the work with respect to sort of drilling down and determining what the issues would be. And keep in mind that, you may have sort of zeroed in on what the issues are, but there's a certain fluidity to that. The way you see things and the way you've crafted the issue may not necessarily be the same as that of the defendant. The defendant may take a slightly different approach. They may have crafted the issue slightly differently. So it shouldn't be cast in stone. It shouldn't be static. There should be a certain sort of flexibility, an ability and an elasticity that allows you to sort of incorporate your other perspective in terms of what you have identified as the issue. And of course, the relevant evidence and the law that you're going to be marshalling with respect to that issue. So here we have the chronological order. Here we have a date, an event, and is there something that is worthwhile noting with respect to the sort of the evidential issues arising there, and of course, what are your legal arguments that you seek to bring with respect to that particular issue? That's what this chronological approach sort of suggests. You say the date, you say the event, you say, what's the applicable issue, and that sort of helps you to, again, continue to structure that battlefield, if I may say, in terms of giving it sort of coherence and an ability to sort of organize the data that you would want to rely on in a trial down the road. this is the outline method that I previously sort of alluded to, and this is where the issue, you would have done the drilling down and the evidence and arguments, and then the comments, just some of, comments or remarks that you might have with respect to this, the issues that you have identified in connection with your file. Here we look at law and evidence and what I call an inseparable union for trial. There is a symbiotic relationship between the two. Evidence, the existence of a set of facts or the inference that you can draw on them, and the law that is applicable. Both of them most of them must be in unison. But again, we look at what are the various issues. What are the, what's the sort of the accompanying evidence that you need in order to establish it? And this sort of gives a bit of a sense of, what is the size of the issue? And I'll unpack this chart in my next slide, and the evidence that you need to bring for that purpose. So with respect to the chart, you're asking yourself, what is the nature of the evidence? What is the nature of the evidence and the law required to succeed on this issue? Is the evidence and the issues to be advanced at trial aligned? Alternatively, are there gaps between the law and the evidence? If so, have you adverted your mind to remedying those gaps? What uncertainties arise, both in relation to the evidence and to the law on the issues to be determined at trial? If any, do you have relevant jurisprudence to address them? And following the charts, obviously issue 1 is the behemoth. The same thing goes for issue 2. But keep in mind, of course, that if the nature of the evidence raised in respect to issue 2 in the chart differs, then that might lead to a different set of questions. Same thing applies for issue 3, and same thing applies for issue 4. Now, to close the loop on that, the question is, at least to me, the question I ask is, on what hill do we die? Is it issue 1? Is it issue 2? Or is it issue 3? Issue 1, for an example, represents an outsized issue compared to the other issues. Everybody, every litigator would know that there is a central issue which, if resolved, potentially would resolve the trial. We all sense of know that, but as a precautionary measure, we slap in or we throw in a lot of things, hoping that perhaps one will stick. But we know there's one central one that is critical that we succeed on, in a sense, at least in my experience. The relational perspective from the chart also sheds light on quantum, what I call quantum, that is, and the evidence arising at trial. They differ in significance and in importance. Furthermore, are there elements of other issues that are illuminated by evidence advanced in respect of a particular issue? Alternatively, does the combined reading of the evidence, for example, change the tenor of the issues as well as the evidence to be determined in the trial? So the chart sort of reflects the union of law and evidence with particular issues, but there's also a potential relational element in terms of the interplay of the evidence. Does it suggest new things? Does it shed new light? Does it illuminate, in the sense? So these are not sort of isolated categories per se. There is, I would argue, a relational aspect in sort of looking at this from a combined set, because we might change the tenor of the issues actually that we propose for the courts to deal with, or they might sort of raise new questions in respect of the issue that we're asking the court to sort of settle. Now to the question of, you could have done all this work, but there's still, there's still the prospect of surprises, and the litigator will tell you that. You can do all the best you can, but when other people are looking at your work, they will always come at it from a different angle. They will always come at it from a different perspective. And so what we are mainly doing is to mitigate or to minimize the prospects of surprise, not to completely rule it out. And so I suggest that if the geography of the evidence is adequately covered, then the prospects of surprise is mitigated, not completely removed. As a litigator, we can never remove prospects of surprises. And when they do happen, I don't know how, sort of senior counsel here will deal with it, but over here, you have to speak with candor. If you don't, you sound funny. They can tell. The relationship between counsel and judge here is so very intimate. It's like you're having a conversation. It's hardly sort of aggressive. As we see elsewhere, it's very intimate. They can, if you need to take a moment, they will grant you a moment to take time off and to sort of go reflect on what has come up. And because at the end of the day, if everybody has a sort of a better understanding, then justice is done, and not a technical justice in a sense that we see. And also perhaps another way would be to sort of attempt to link the surprise to something that has already been discussed, and perhaps by doing so, you drain it of the surprise factor. So those are the kinds of things, or it's kind of approaches that are sort of used, deployed, and sort of been sort of successful, rather than to boneheadedly continue arguing and continuing to argue with the judge and piss the judge off. And at the end of the day, actually, the judge is going to be going to be the one making the decision on your part. And so we try the best as we can to sort of minimize the prospect of surprise. And even when the surprise does happen, we should be candidates either in owing up what happened, or in being honest and truthful in terms of sort of dealing with the issue that has sort of surprisingly come up in the context of the conversation. Now, addresses, I didn't focus too much on these addresses because what we see as addresses, by the time you're getting to an address, probably the ship has already sailed, the work would have been done way before the addresses. The addresses are just an end product. The hub of the analysis, the intellectual heft you bring, precedes the address. That's what I'm trying to suggest. The work you bring with respect to sort of segregating the evidence, determining what is real and what is unreal, what is real and what is phantom, and what are your gaps, what is illuminated, what are the, what you need to enrich, what's the relationship between your various aspects. That's where the work is. By the time you're getting to an address, that work, you cannot start arguing law in an address. The judges here don't have time for that. I mean, you can argue, but whatever you're arguing has to flow symmetrically from what you have presented. That's not an area for you to start introducing new things. So the address flows seamlessly from the work you've done prior to it. And so that's what I say, that the area work to make this an easier enterprise. The address becomes an end product of the antecedent work that went into analyzing and organizing the evidence. While we typically submit addresses, my personal preference is to summarize it, is to speak to it, and potentially also take questions from it. I would always like to speak to it. I would have sort of done sort of a summary flowing from all the work I've done, and of course a summary of the written address. It's just like 2 weeks ago I was before the Court of Appeal. The Court of Appeal starts its deliberation here by telling you, counsel, thank you, but we have your factum before us. Factum being what we call briefs in Nigeria. And so if there's any aspect of it that you wish to sort of elaborate on, go ahead. But we've read your material. I mean, these are 3 judges. We've read your material. And, you know, it's very clear to us the position you're taking, but you can go ahead and sort of go ahead and make some further submissions. And so you just go ahead and knock on some key points and step back. And again, the taste of the pudding is in the eating. It comes in a question and answer session. That's where some of the things will come out. That's where you might draw their attention to certain facts, what we call extracts of key evidence, certain things that they have not adverted their minds to. And the same thing with respect to the ordinary address here. It's not a place for you to, you know, start re-arguing your case. I mean, you can do that with some flourish at this point in time, but you're sort of linking back to what you did in the past with respect to organizing, identifying the issues, the law, the evidence, and you're just drawing a link for them to see that this is what has led you to the point you are here. Writing, you know, I used to teach legal research and writing here. We always ask people to keep it simple. I see students who are transitioning from Nigeria to hear a lot of the Latin maxims. Over here, they don't like that. They try to sort of cure you on your Latin maxims. But I mean, we still, you know, we still bring it in now and then. We still say things like inter alia and all that. We just can't avoid those. But the idea is to keep it simple, you know, short of a Latin maxim, and allow each paragraph to speak to a specific, you know, to a specific issue as much as possible. They match 2 issues on any particular paragraph. Otherwise, it's sort of difficult to follow for the addressee, in this instance being the judge. So those would be my comments with respect to the topics that are provided to me. I probably would just leave it at this point. Conclusion, of course, is that there's a serious relationship between the evidence and the law. My hope is that we can try to deploy the techniques that are sort of highlighted here, and in terms of how you organize the evidence, the law, and how it might be marshaled in the context of a trial. The execution can be laborious, but as all things, the more we do, the better we get at it. You know, I tell people that law is experiential. It's not about reading it. Over here, you know, you gotta do it for you to internalize it better, for you to understand it better, and for you to be in a position to speak it. You know, the more we do, the better we get at it. Again, what we see, then see and address is a reflection of the antecedent work that has sort of gone into marrying the law and its accompanying evidence. So those will be my comments. I'll leave it here, and so I suspect we will have more questions. But thank you for that.
Thank you very much, Leonard Silk. This has been enlightening. It's a completely different approach, but it's manifestly it speaks for itself. And I think it's similar to what Mrs. Adekoya said, about knowing your case inside out from the front. From A to Z and from Z to A, knowing all the issues, analyzing the issues, and you spoke about the various techniques for identifying issues. Talk about the bramble bush and making sense of all the issues in the pleadings and organizing the evidence and reviewing the evidence and connecting the evidence to the pleadings and you gave us the various techniques. This is new, but I can immediately see the value to taking this very scientific, this methodical approach to which we also do, but obviously it has become a science there, and it seems the emphasis is on getting the facts and the issues and all that. And I know some lawyers speak about lawyers of facts and lawyers of law. I think you have to be a lawyer of facts and law anyway, because the laws don't operate in they don't operate in isolation from the facts. And again, some people think overemphasis on the law. Obviously, you were also talking about avoiding technical justice or technicalities and all that. And that bears to getting the facts right and understanding them completely inside out and presenting them in a logical, accessible, understandable way. And the only way to do that is to be a master of the facts and the evidence yourself as counsel. And obviously that plays into your being able to present it in an understandable way to the judge. And obviously, from what you say too, it's the approach is not just from the judge, but from the lawyers, but even the bench takes the same approach to reviewing. And obviously you speak about the team around the judges and all that. And I think some of these things we're trying to adopt them. At least judges now have research assistants and things like that. But obviously, you have a system that is probably more robust, and but it's for me it's very enlightening, very interesting. I think as my principal partner used to say, he always believes that facts win cases. Not the law is important, but you need to get the facts right and get it completely right. And but he always argues that facts are more important than law in winning your case. And I think your approach also seems to suggest that very strongly. Thank you very much. This is enlightening. This is a good perspective, and I'm sure that our colleagues have a lot to learn. Thank you for the slides. We will share them. A lot of people have been asking for the slides, and I'm sure as we chew on the slides, we'll get into some of these skills. And I'm sure I'll just hand over to Mrs. Okereke and allow her to anchor the question and answer session. Thank you very much.
Thank you.
Thank you so much, Leonard Silk. As you were making your remarks, there was some other thing that I saw being covered in the context of this, and this is sort of the rise of artificial intelligence. We're seeing increasingly artificial intelligence coming in to help us to sort of do the issue identification and sort of help us to map the data around which we will intend to sort of advance an issue, whether it's with respect to the evidence or with respect to the law. But sometimes what we find, whether it's with Nigerian students who are sort of transitioning here, or whether with sort of new students who are leaving law school here, the traditional work that we do, and this is to your point with respect to the facts potentially win cases. The traditional thing to do is to bring the sort of the thinking that sort of, how are we connecting the dots? Are we connecting the dots sufficiently, as between the facts, as between the law? On one hand with respect to the facts, on the other hand with respect to the law. And I think that's still an area that AI continues to struggle. We still have to bring that thinking cap for us to determine what is the relational aspect between the facts, and perhaps that is what will segregate or will take us outside the parameters of an existing law. That's still what we have to do. with respect to, we're still not replaceable by machines. The machines can continue to try, but this is what we do, and this is what separates us in some sense. I mean, the machines are closing the gap. I still, I can see, but we still have to bring that intellectual head, that questioning, that continuing to sort of interrogation of the facts and do the linkage to the law. That's where new law is created. That's where perhaps we can say that the ratio does not apply to our case, and that's how we can perhaps differentiate and distinguish cases. I think that's something that is uniquely human for now.
Thank you very much.
Thank you, Leonard Silk. Permit me to just deviate slightly from the norm. Our participants here are very, very grateful. And some of the words I see them put in the chat box, they say, this has been illuminating from a different perspective, insightful, interesting, enlightening. And we have so many comments out there thanking you profusely. I'll jump on the questions very quickly from Uyoko. Uyo, forgive me, UU, initials. Good evening, sir. Kindly confirm if the corrective admissibility principle applies in Canada. If yes, kindly elaborate on its application.
Corrective admissibility principle. The concepts of admissibility here are the same. Is it relevant? There's no major difference between, at least so far as I have found. I'm not quite sure what you're referring to as a corrective principle. Over here, there is the sense of if it is not, if it does not unduly prejudice the other party, the courts are very flexible in admitting documents. And perhaps what they will do is to pivot once they've admitted, to pivot subsequently to determine the weight to attribute to it. And that's pretty much how they're not really hung up on admissibility per se. They will bring it in and then determine what weight to attach to it.
Thank you so much, sir. Stephen says, this is what I want to know. After close of evidence, when a party has pressed, suppose a new evidence comes into play, and in the opinion of that counsel, it's very fundamental to this case. Is it possible to reopen the case? If yes, how?
Well, the principles would differ. I don't know the principles with respect to Nigerian law, but over here, yes, you can bring an application. Seeking to introduce that new evidence. And the parameters will be, is it compelling? Is it something that you ought to have discovered with relative ordinary diligence and things like that? And does it sort of have implications for doing justice in the file? I suspect that the principles will be the same, will be identical, but yes, you have to bring an application to bring something after the close of the case. You have to bring an application. In a file that I did in the past, that application was brought. In that particular instance, the new evidence worked for both parties. And so by consent, we agreed. And typically when we do things by consent, like here, the judges will just admit it and say, okay, since both of you want it, I'll bring it in and let's look at it.
Thank you, Leonard. So
I think the position is largely the same here. You can always bring an application to reopen your case, to adduce new evidence or to recall a witness. And I think it's basically up to the discretion of the judge. Like you rightly pointed out, if the opposing party does not oppose you, the adverse party does not oppose your application, then the court will probably grant it. But where it does, the court will have to consider whether it's prejudicial and how important the evidence is, the time, and whether and all the other basic considerations in exercising the discretion. I think it's up to, but it's in principle, it's possible.
Thank you. What is the effect of witness statement on oath? Which evidence was given but not adopted in court in the course of trial?
Witness evidence on oath.
Witness statements on oath.
Yeah.
Which evidence was given but not adopted in court in the course of trial?
Well, our antecedent processes differ. And you know, sort of, I might invite people from the, you know, sort of practice in Nigeria. Our antecedent processes differ. And so there are different rules with respect to how to bring in evidence which we have generated earlier. Over here, once these deals are closed, we go into what we call examinations for discovery, or what the Americans will call depositions. And so we gather documents from each party, what we call an affidavit of records. We gather documents based on an affidavit of records. The documents that are produced are called productions. Now, when those productions are produced to counsel, you have a right to question on them, right? And these questions are questions that are, you know, we are going to learn more about the case. We are seeking admissions that we might rely on later on a trial. And so there are technical rules with respect to that process, the process of what we call questioning here. I suspect that's not the same with respect to the Nigerian system. And so the antecedent processes with respect to the evidence that is already generated prior to trial and how that might be used at trial will differ for us. So I'm sorry, probably that doesn't quite answer the question, but you know, just I can only speak with respect to the practice here.
Okay, so I mean, the point you make is very, very interesting, because I think I threw it up yesterday in the process, and you are right. We depositions, I was talking about depositions yesterday, and the fact that although our rules speak about it, nobody ever does it. I've been involved in a few, not too many, multi-jurisdictional cases where you have to work with lawyers in other jurisdictions, United States, and I see you mentioned depositions and you have a different terminology for it in Canada, but it's a big part of litigation in the United States. And incidentally, we have rules regarding it, the notice to admit documents and interrogatories and all those other tools. We have them in our rules, but we in practice, we hardly use them. And it was in another context that I thought we should actually be exploring the use of positions more in our trial process instead of jumping straight into the trial. And but to answer the question, I think it's simple. If you have a witness statement on oath and you depose to it, you file it in court, but the witness doesn't come to court to adopt his witness statement on oath, I think the court would deem the statement on oath to have been abandoned, because it's not, you can't just place the evidence there, because if you haven't come to adopt the witness statement on oath, the opposing counsel will not have had the opportunity to cross-examine your witness and to test the veracity of your evidence. And the general rule in Nigeria is that, I mean, where you have, even in the days before witness statement on oath, if, for instance, a witness passes on after giving his evidence in chief, and you haven't had the opportunity to cross-examine that witness, the court tends not to rely on that evidence. And so, I mean, if you have a witness statement on oath, you haven't adopted it, you haven't been cross-examined, then that evidence would probably just be, in fact, it won't be evidence before the court. I think that's the short answer. But I think you also make a very interesting point about the use of depositions, gathering documents, and notice to admit, and interrogatories, and all those, and discoveries, and all those things. We don't tend to use, whilst our rules speak about them, and I was making that point yesterday, we tend not to use them, and there's a role they play. in our litigation, and maybe we have to do a separate trading on some of these areas where we have provisions in the rules, but we just generally seem to ignore them. Thank you very much for
just to add to that, we actually have interrogations here. We have notices to admit. Everything we have that here as well. The whole idea is also to continue to narrow what are the issues that are arising between the parties. But the positions of what we call questioning here is a completely different animal, where it's sort of part of the litigation process where we can now start asking questions of the documents that have been produced. And those questions, the questioning here serves a number of purposes. For the purpose of sort of obtaining admissions, it allows us to learn better the sort of against the client, and also perhaps to see whether, see how they perform. It's almost like mimicking what happens at trial. So it's a trial balloon in some sense. It allows you to see the demeanor of if your witness capitulates in a questioning or in a deposition, then you probably don't want to take that witness to trial. you might say, you know what, at the end of this process, you're very uncomfortable. I see how distraught you are. Perhaps we should settle this. And so that's also a part of sort of the litigation process. And of course, if we do have certain admissions, we can rely on those admissions at trial by what we call readings. In other words, related to specific issues that arise on trial. If you change your story, we can refer to this because it's actually a court proceeding that occurs outside of the court, in our offices, right? But there's a court reporter who is there, who takes notes and who produces a transcript. So there's a transcript of what transpired, and you are sworn. So it's like a deposition, like I said.
Thank you.
Interestingly, like I said, we have it in our rules, but nobody uses it. But it's interesting you make the point. Thanks.
Thank you. This is from an anonymous attendee. It says, great presentation. I want to find out if virtual hearings are the norm in Canada. Nigeria is yet to totally adopt this type of hearing. Not all states have adopted virtual hearing.
For the COVID periods, virtual hearings were now the norm. I tell you, some of us don't like it because the litigators want to be in the courtroom. That's where we get our high, so to speak. we need to be in the courtroom. We need to sort of be engaging with the judges, and there's something distant about sort of a remote setting. But increasingly post-COVID, this is 2022, 2023, the courts are now increasingly by what we call practice directions here. The courts are increasingly asking us to come before in person physically to address them. But in some instances, say for example, I have a matter in Edmonton, which is the capital of the province here. I can write to the court, and the court will sort of grant that sort of privilege, that discretion, and say, you know what, you don't have to travel down to Edmonton. You can conduct the hearing by Zoom. And so sometimes you could have a lawyer in Toronto, I'm here in Calgary, another one in Edmonton, and we all sign through the court link, and we can argue sort of an application. With respect to cases and trials, the practice now is increasingly to have it done in person.
Thank you. Victor Chukuma says, thank you, Leonard Silk. Apart from pleadings, is there any other way of determining what facts are relevant or not? What if a fact is not pleaded, but it appears to be relevant to a pleaded fact? Can issues be framed from such facts?
It reminds me, even though I have been stripped of of my legal maxims. This reminds me of nemo that quod non habet. You you can't place something on nothing and expect it to stand. The pleadings are the fundamental basis for determining what is relevant and what is not. And if subsequently something became relevant, it depends on the time. You can bring an application to amend your pleadings, but the later in time, the more you wait in order to amend the more pleading, the more precarious it is for you to bring it back in. I mean, if it's something that just sort of, like every litigator will do, we'll just do a quick statement of claim, quick statement of defense, get it in there to meet, over here we have a 20-day deadline in order to serve a statement of defense in response to a claim. You serve something very quickly, but you can then subsequently amend to bring a new fact or whatever, alleged new facts, by way of a defense or by way of a claim. But if we're right in the middle of trial, or just we're all getting set for trial, and you're suddenly realizing that there's an issue that you need to bring in, I think it's tough luck. It's still where you're gonna bring it in.
Thank you. What is the effect of a witness statement on all which evidence was given but not adopted? I think this has been taken. There are lots of questions here. If we will provide the recording of the training. Another one says, we do provide lectures and recording. What is the fate of the document admitted during pre-trial but not admitted during trial?
That's unlikely. If it is admitted, it is admitted. That's unlikely.
The effect. Wow. I see comments here on recordings and slides. Yes, we'll provide them. Thank you, Leonard. So can a party raise a preliminary objection to an issue that has been pleaded?
At what stage? Is it prior to trial or trial? You can raise a preliminary objection at any point in time, especially if it is a point of law. Again, these are sort of, when I navigate two legal walls, this is where they unite. The preliminary objections can be raised at any point in time.
That's the same here.
Yeah.
Is it procedural? I guess this person wanted to ask Mrs. Adekoya this question. Is it procedural to show a witness a document for identification without tendering same?
I'm not sure I can answer that.
Maybe I can attempt. I mean that's a practice in Nigeria. They bring documents and they say it's for identification. There is nothing like that in the rules of court or in the Evidence Act. But in practice, of judges allow it. Then they subsequently maybe a document they want to tender and it's not in the form in which it could be tendered, or the witness through whom they want to tender has not been called, so they bring the document for identification. So it's there for ID, and then at a later stage they might attempt to tender it. I don't know where the practice came from, but it exists. But it's not.
It does. Actually, I didn't hear. Yeah. I didn't hear the question. It does exist here as well. We do have identification, but identification is not admissibility. They should not be confused.
Exactly.
Yeah, so that's pretty much it.
Then it appears that we have loads and loads of comments in here, and our colleagues have all dropped their email address. And the questions I keep getting repeatedly here is if we will share your slides with them. Thank you, Leonard, for this wonderful presentation. How can we get your slides? Both presentations are fantastic. For the slides, please. Slides, please. Thank you for this presentation. Slides, please. Thank you for the lecture. Slides, please. So I think everybody is asking for your slides, and all of the comments here just goes on and on for slides. So I'm trying to thank you. This has been a most fantastic session. The same we had both sessions. They were wonderful. Thank you, Mrs. Adekoya. I'm still reading from the comments here. Please, can we have the slides? Many thanks to Leonard Silk, Mr. Gopabi for the presentation. Please, let's have your slides. It's from Ahmed. Thank you, Leonard Silk. Thank you so much for. Leonard Silk, I could go and on, and our participants are full of appreciation, and I join them all to say thank you to you and to Mrs. Funke Adekoya. From this end, I'll draw the curtain. Thank you. Over to you, please.
Thank you. Thank you very much. I'm hoping that my Leonard Silk and friend Tola Oshobi will come to Canada. I'll be very glad because
I will take you up on that offer. Thank you. Thank you so very much for the presentation. For me, it's been very enlightening. It brings a completely new perspective about how we can do things differently and in many ways better. And I'm very thankful for your time. I know we can't pay you. I know your hourly billing rates are the stratosphere. So I thank you to remember your colleagues back home and take and contributing. Thank you so much. This has been enlightening. We will definitely share the slides with all our colleagues. And I would also look at the slides again because I think there's a lot to learn from them. Thank you so much. I wish you a very pleasant day and the rest of your day. I know it's morning in Canada, and you must have woken.
10:09 a.m.
Exactly. So I wish you a very pleasant day, and I also wish you a very pleasant and restful weekend. Thank you so much.
Thank you.
Yeah, bye-bye.
Bye.
Okay, so this is where we draw the curtain for this week. We'll continue next week with day 7. We'll start with Mr. Babajide Oguntike, and he will be taking us on judgments and enforcement of judgments. And then we have Justice I.M. Buba, who will be taking us on preservative proceedings pending appeal. So we will continue next week. Thank you very much, everyone. I wish everyone a very pleasant weekend.